Chapter 26. Conveyances valid between the parties. Relief to defrauded grantors. SS 395. Conveyances binding between the parties. The statute under which fraudulent and voluntary conveyances may be set aside. 13 Alis. C5. Ordinarily has no application to the parties to such instruments or their representatives. In Jackson v. Garnsey, Spencer, C.J., in referring to this subject, use these words, as between the parties they are expressly excluded from its operation, and are left as they stood at the common law. And before the statute the heir could never set up his title against the voluntary alienee of his ancestor, nor call upon him for contribution, where both were amenable to the creditors of the ancestor as tenants. Nor will courts of equity assist the party making a voluntary conveyance or his representative claiming as such, by setting them aside. The cases holding such conveyances binding between the parties are numerous. The same rule pertains to general assignments which, though voidable by creditors, are always valid between the immediate parties. The conveyance, as between the parties, stands upon the same ground as if a full and adequate consideration had been paid. It is held in conformity with this rule that a debtor who has conveyed his property in order to defraud his creditors has no standing in a court of equity to question the fairness or adequacy of price obtained at the public sale of the premises on a creditor's bill to reach such property. It is not material whether the party is alleging the fraud as matter of defense or as a ground of action. 4. As was said by Lord Mansfield, no man shall set up his own iniquity as a defense, any more than as a cause of action. SS 396. The theory, no reconveyance. Lord Chancellor Thurlows declared his opinion to be that in all cases where money was paid for an unlawful purpose the party, though particeps criminais, might recover at law, and the reason was that if courts of justice meant to prevent the perpetration of crimes it must be not by allowing a man who has possession to hold it, but by putting the parties back in the condition in which they were before entering into the transaction. The doctrine of the learned Lord Chancellor would seem to be sufficiently broad to cover the cases of conveyances made in fraud of creditors, yet the authorities, as a general rule, reveal a singular absence of any disposition on the part of the courts to extend relief to fraudulent grantors. A fraudulent vendee is under no legal obligation to reconvey, though morally bound to do so. And a court of equity will give no aid where both the vendor and vendee participate in the illegal transaction. It is familiar learning that equity will not decree a specific performance of an agreement by the fraudulent grantee to reconvey the property to the debtor, and will not interfere to correct a mistake in a deed that was executed for a fraudulent purpose. And if a party obtains a deed without consideration upon a parallel agreement that he will hold the land in trust for the grantor, there is authority to the effect that such trust will not be enforced, as it would violate the statute of frauds, and also the general rule that parallel evidence cannot be admitted to vary, add to, or contradict a written instrument. In a New Jersey case, it was decided that a note which was given for property transferred to the maker for the purpose of defrauding the creditors of the pay could not be enforced in the hands of the pay against the maker. In the course of the opinion, Chief Justice Beasley indulged in the following refreshing observations. It was urged that the statute for the prevention of frauds and perjuries does not invalidate transactions the end of which is to prevent or make difficult the collection of just claims, except so far as concerns creditors, and that, inter partes, such transactions, if containing no other infirmity, will be effectuated at law. It is certainly true. The statute referred to does not, propria vigor, annul beyond the extent thus defined the conveyances and contracts at which it is leveled. Nothing more than this was necessary to effect its purpose, which was the relief and protection of creditors against this class of frauds. But it is also clear that it has no tendency to legalize any act which was not legal at the time of its enactment. A contract, the purpose of which is to protect a debtor against the just claims of creditors, is an immoral act. Such an affair is inimical to social policy. It is in direct opposition both to the letter and spirit of the statute for the prevention of frauds. In their essence and in their effects, such contracts are as immoral and pernicious as many of those which the law has declared to be utterly void. In these respects, how are they to be distinguished from contracts to indemnify persons against the consequences of their illegal acts, against liability for the publication of a libel, from promises by uninterested parties to furnish money for the prosecution of lawsuits, from agreements in contravention of the Bankrupt or Insolvent Acts, or in general restraint of trade, or from that host of other conventions, which have been so often judicially condemned, not on account of any enormous immorality, but on the score of their inconsistency with public interest and good government. I can see no reason why contracts to defraud creditors should stand on a different footing from the rest of those embraced in the class to which they evidently belong. They are hostile to fair dealing and commercial honesty, and, on this account, should be subjected to the ban of outlawry. SS 397, Massachusetts cases. In Massachusetts, a long series of cases has established the rule that a transfer either of real or personal property, made with a view to defraud the creditors of the grantor, although the grantee has participated in this intention, is good between the parties and void only in favor of creditors, or to speak accurately, is voidable by creditors at their election. If no creditors intervene, the conveyance stands. If creditors elect to affirm the transfer and receive the consideration, it is thereby ratified and confirmed. Payment of the grantor's debts to the full value of the property purges the fraud. This doctrine extends to executory contracts. In Freeland v. Freeland, the court say, a conveyance made in fraud of creditors is valid as between the parties, and can be avoided only by creditors or by the assignee in insolvency representing them, and, if he affirms it, it stands good. SS 398, General Rule and Policy. These covenous conveyances are binding upon heirs, legatees, and, as is elsewhere shown, in certain cases upon personal representatives and assignees. The fraudulent conveyance is treated as so far upon the valid that creditors of the vendee may seize property and may even cancel a reconveyance of it to the grantor, though a reconveyance cannot be enforced. The fraudulent vendee is said, in some of the cases, to be under a high moral and equitable obligation to restore the property. The law is not so unjust as to deny to men the right, while it is in their power to do so, to recognize and fulfill their obligations of honor and good faith. And until the creditors of the vendee acquire actual liens upon the property, they have no legal or equitable claims in respect to it, higher than, or superior to, those of the grantor. It has been contended that the transfer only made visible an ownership which already existed, though secretly. The boundaries of these rules as to the conclusiveness of voluntary or covenous conveyances between the parties have, however, been broken over in some instances, and the rule itself has been questioned upon the theory that both parties are seldom equally to blame in a transaction tinctured with fraud in each, and if they are, the doctrine seems to encourage a double fraud on the one side to punish the single fraud on the other. SS 399, when aid will be extended to grantors. This rule, it has been said, did not in the nature of things apply where the grantor was not in pari delicto with the grantee, as where a creditor availed himself of his power over a debtor and induced him by misrepresentation to make a fraudulent conveyance to him. Thus in Roman v. Molly, the doctrine is asserted that there may be different degrees of guilt as between the parties to a fraudulent or illegal transaction, and if one party act under circumstances of oppression, imposition, undue influence, or at a great disadvantage with the other party concerned, so that it appears his guilt is subordinate to that of the defendant, the court in such case will extend relief. Parker, J. said in James v. Bird, there is no case in equity where any relief has been given to a fraudulent grantor of property, the conveyance being made to protect it against his creditors, except that of Austin v. Winston, decided by a divided court, and perhaps, under the circumstances, properly decided. The authority of the case, however, has been in some measure acknowledged in several states. The court in Fletcher v. Fletcher conceded that it would assist the grantor in cases where circumstances were shown which warranted its interposition on recognized and settled grounds of equity jurisprudence, such as fraud in procuring the deed, imposition by the grantee in violation of some fiduciary relation, delusion, or the like, on the part of the grantor at the time of executing the deed. In Pinkston v. Brown, it appeared that at the time the deed was executed the plaintiff was old, infirm, weak of mind, and much diseased and distressed in body. The deed was made with a view to hinder and delay the collection of a debt. The party benefited was the plaintiff's oldest son, in whose ability and integrity she had the greatest confidence. The transfer had undoubtedly been consummated by means of the undue influence and deceit practiced upon and exercised over the aged and confiding mother by the son. The court held that the mother and son were in delicto, but not in pari delicto, and at the suit of the mother set the transaction aside. In a case which came before the Supreme Court of New York, a sued B for slander, B to protect himself conveyed property to C, who agreed to reconvey. B defeated the slander suit. It was held that C must reconvey. Johnson, J. said, Gilman had at the time no other creditors, and his sole design was to get his property out of the way of any judgments which might possibly be recovered in those actions, and not to hinder, delay, or defraud any other person whatever. It turned out that the several plaintiffs in those actions had no lawful claim against Gilman. They were not creditors, and, as to them, the conveyance was valid, as it was. Also, between the grantor and grantee, it was not designed to defraud the plaintiff of his claim, as the referee expressly finds, as this conveyance was not made with intent to hinder, delay, or defraud any existing creditor, or any person having a lawful claim, but only a person making an unlawful and unfounded claim, which the defendant Gilman disputed and denied, and ultimately defeated. It may present a grave question whether it falls at all within the condemnation of the statute. The sole object of the statute here, in declaring conveyances void, is to protect and prevent the defeat of lawful debts, claims, or demands, and not those which are unlawful or trumped up, and which have no foundation in law or justice, and the verity of which is never established by any judgment, or by the assent of the person against whom they are made, as against claims and demands of the latter class. The statute does not forbid conveyances or assignments, nor declare them void. It may well be seriously questioned, however, whether this contention can be uniformly upheld. The courts would be justified in refusing to inquire whether the grantor's apprehensions as to the recovery of a judgment against him were well or ill-founded, and might well incline to leave the parties in the position in which it found them. SS 400, Cases and Illustrations. In Boyd v. de la Montagne, it appeared that a husband had secured a gratuitous transfer of property from his wife by means of false representations on his part that she was liable for a debt, when in fact no such liability existed, though the transaction was consummated in the belief that the effect of the transfer would be to hinder and delay the creditors, or in some way to save the property. It was held to be no answer that the wife consented to the act with a view to defraud creditors. Chief Justice Church said, "The parties do not stand on equal terms, and the husband cannot avail himself of the plea of particeps crimines on the part of the wife. A court of equity will interpose its jurisdiction to set aside instruments between persons occupying relations in which one party may naturally exercise an influence over the conduct of another. A husband is held to occupy such a relation to his wife, and these equitable principles apply to them in respect to gratuitous transfers by the wife to the husband. So in Freeland v. Cole, it was decided that as there are degrees of crime and of wrong, the courts can and will give relief in many cases as against the more guilty. To exclude relief in such cases," said Smith, J., "the parties must not only be in delicto but in peri delicto." Applying this doctrine, it was held that where the plaintiff was infirm of mind and incompetent to manage and conduct his business affairs with ordinary prudence and discretion, and the defendant was his son in law, confidential friend, and legal advisor, and had procured a conveyance to himself of the property in order to place it beyond the reach of the plaintiff's creditors, relief might still be accorded the plaintiff. Ford v. Harrington, an important and leading case in the New York Court of Appeals, in which judges of the eminence of Denio, Johnson, Comstock, Selden, and Brown participated, seems clearly to establish the same general principle. It was there expressly held that where an attorney procured from a client a conveyance of a valuable interest in land for a manifestly inadequate consideration, the conveyance being advised by the attorney with a view to defeat a creditor of the grantor, though the agreement was illegal, yet the rule prohibiting the attorney from obtaining any unconscionable advantage in dealing with his client must prevail, and the attorney could be compelled to reconvey the land, and were the parties to a conveyance or brothers, the grantor being crippled and diseased in body, weak in mind, and easily influenced, and under the control of the grantee, who was a person vigorous in both body and mind, the conveyance was set aside at the suit of the grantor, it appearing that no consideration was paid, that a reconveyance was promised, and that the transfer was induced by operating upon the grantor's fears that he was in danger of losing the property by reason of a breach of promise suit which had no foundation in fact. SS 401. The case is just considered exceptional. The practitioner, however, must be careful to remember that the cases just considered are exceptions to a well-defined and almost universal rule, while it is possible to deduce from them a general principle that degrees of guilt will be recognized in such transactions, and that grantors may, in certain cases, reclaim the property fraudulently alienated where the transaction was superinduced by the unfair action of a vendee who occupied some relation of confidence which enabled him to unduly influence the vendor. Yet a very clear case with well-defined reasons for accepting it from the general rule must be presented. debtors contemplating fraudulent alienations should draw little encouragement from these exceptional cases. 4. As a general rule, after passing through the troubled waters of insolvency, they will find themselves stripped of the power to reach or recover the secreted property in the hands of their fraudulent grantee. The ancient rule, in peri delicto melior est conditio posse dentis, is not to be easily uprooted and must not be considered as overthrown or abrogated by these cases. The great effort has been, in at least a portion if not all of the cases just considered, to show that the parties were not in peri delicto because of the reliance and confidence placed in the grantee, especially when he assumed to advise or act in a professional capacity, or occupied a position where he could exercise undue influence over the vendor. In Renfrew v. MacDonald, the fraudulent grantor, seeking to set aside a conveyance made to hinder creditors, was summarily dismissed on the opening oral statement of his counsel. The plaintiff alleged great intimacy with and confidence in the defendant, and charged that it was through his influence and procurement that the fraudulent conveyance had been made, and that defendant had knowingly advised plaintiff that he had no defense to certain notes, the collection of which plaintiff sought to hinder and delay by the conveyance in question, when in fact a defense did exist. The court said, nothing is alleged by way of excuse for the attempted fraud, except what might be with more or less truth alleged in every case. The recipient of property with intent to defraud creditors possesses the intimacy and confidence of the fraudulent debtor, and advises the attempted fraud and consents to be made the instrument thereof, to allow the grantor in such a case to set aside the grant and be restored to all he has parted with for the illegal purpose, would be to afford great encouragement to future attempts of that character. In Fredericks v. Davis, the doctrine is asserted that the grantor in an alleged fraudulent conveyance, made with full knowledge of the facts, is estopped by his own warranty of title from testifying that the conveyance is fraudulent. This doctrine is supported by the case of Phillips v. Worcester, wherein the court say, the position which the plaintiff occupies in relation to the transaction complained of as fraudulent excludes him from alleging the fraud, or claiming any benefit against it. The conveyance against which he now seeks to derive advantage from the property was made by himself, with a full knowledge of all the facts as they existed at the time, as we are bound to presume since he has shown nothing to the contrary, so that if the money paid was the debtor's, as he now insists it was, and the conveyance to the wife therefore fraudulent as against creditors, it was not fraudulent as against him, for he was not only consenting to the act, but himself performed it. SS 402, grantee enforcing fraudulent deed. The rule being established that the courts will not interfere to set aside a fraudulent executed contract as between the parties, it has been contended that the same principle would preclude the grantee both from enforcing his apparent right to the possession of the land under the deed, and from collecting the rents or damages, a consideration of the reason and policy of the rule, however, led the courts to hold otherwise. It is considered a mistake to suppose that the parties being in peri delicto, the court would refuse the grantee all remedy. The deed as between the parties is perfectly good. The grantor, by a stern but necessary policy of the law, is excluded from presenting the proof which would show the fraud. He is in this respect the actor. His fraud silences and estops him from averring against his deed. The rule operates only in cases where the refusal of the court to aid either party frustrates the object of the transaction, and destroys one of the temptations to enter into contracts violating the policy of the law, to permit the grantor, when sued by the grantee, to plead the mutual fraud of the parties, in order to enable him to avoid the effect of the deed by being permitted to remain in possession of the property without the payment of rent or damages, would virtually be permitting him to reap the reward of his own iniquity since he was the real actor in the fraud, and would tend to encourage others to violate the law, with the hope of profiting by committing frauds upon their creditors. It would nullify the rule. There is a distinction between an executed and an executory fraudulent contract. As to the latter, the court, where the parties are equally participants in the fraud, in peri delicto, will leave them in the predicament where they place themselves, refusing any relief or interference, and where the contract is executed, as by a deed transferring the title. The court acts upon the same principle, declining either to cancel the deed or restore the title, but the effect is very different. In one case, a specific performance will be refused, in the other the fraudulent grantee remains owner of the estate as against the grantor, and all the world except the defrauded creditors. SS 403. Fraud upon a debtor is distinguished from fraud upon creditors. Fraud practiced by a third party upon a debtor is manifestly a different thing from fraud upon creditors. and it may well be doubted whether a creditor can seize property the title to which has passed to a third party, or attack such a conveyance where the creditor proceeds upon the ground that the purchaser committed a fraud upon the seller which entitled the latter to avoid the sale. In Garretson v. Kane, the court used these words: "A creditor cannot redress all the wrongs done to his debtor. He cannot claim damages for a trespass or for a deceit. A fraud like that offered to be proved in this case would entitle the seller to relief in a court of equity upon proper terms. And possibly a creditor may have relief there. But he cannot step in and claim that such a sale was absolutely void at law. If he can interfere at all, his rights will be the same as those of his debtor. A creditor who seeks to avoid a sale as fraudulent against him does not represent his debtor, but exercises rights paramount to his. There is in truth no similarity between two kinds of fraud. In the one case it is, either in fact or in law, the fraud of the debtor himself, while in the other the debtor is the victim and guilty of no wrong. A case may occur combining both descriptions of fraud. It will be at once apparent that this element of the law enters largely into the cases in which the debtor or grantor has a standing to attack or avoid his own transfer. SS 404, declaring deed a mortgage, as is elsewhere stated. An absolute conveyance may be shown to be a mortgage. The theory of the decisions is that dealings between the borrower and the lender of money, or debtor and creditor, conducted by requiring an absolute deed for security, and a renunciation of all legal right of redemption, are so significant of oppression, and so calculated to invite to or result in wrong and injustice on the part of the stronger toward the weaker party in the transaction, as in themselves to constitute a quasi-fraud against which equity ought to relieve, as it does against the strict letter of an express condition of forfeiture, the grounds of relief being purely equitable. It may and should be refused if the equitable considerations upon which it rests are wanting. Therefore, an absolute deed made by a debtor to one creditor, with the intention to defraud other creditors, will not be adjudged an equitable mortgage at the solicitation of the debtor. Fraud against creditors cannot be set up, it is true, by any one not standing upon the rights of a defrauded creditor to defeat any legal claim or interest which the fraudulent debtor may seek to enforce, but such a party is in no condition to ask a court of equity to interfere actively in his behalf, to secure to him the fruits of his fraudulent devices. One who comes for relief into a court whose proceedings are intended to reach the conscience of the parties must first have that standard applied to his own conduct in the transactions out of which his grievance arises. If that condemns him, he cannot insist upon applying it to the other party. SS 404A. Redeeming mortgaged property. The courts will not seek to enlarge the scope or legal effect of a transaction that is tainted with a design to defraud creditors. Hence, where property is pledged or mortgaged by a debtor, the pledger or mortgager will be permitted to redeem it, though the design to defraud creditors may have been present in his mind when the pledge was made or the loan procured. Such a transaction does not in itself purport to vest an absolute title in the pledge or mortgagee, and the courts will not strive to enlarge or vary its operation merely to inflict punishment upon a fraudulent debtor by cutting off the right to redeem. Another illustration may be cited. In Gowan v. Gowan, it was expressly decided that where a debtor deposits personal property with a bailee to protect it from creditors, the bailee cannot defeat the debtor's action to recover the property by setting up the fraud.